We'll start the recording now. But once again, this is the NAMI New York State Lunch and Learn. We'll do this again at the end, and I will start sharing my. Yeah, we'll get started now. All right, should be all set. I'm going to. With that, I will turn it over to our speaker today from the New York State Unified Court System.
Good afternoon, and thank you, James. Today I'm going to be speaking about extreme risk protection orders. We have a lot to present today, and I'm going to try very hard to be respectful of the fact that, a lot of people have a hard stop at 2 o'clock or very shortly thereafter because of court and other work. So what I'm going to suggest is my email's at the end of the presentation, and I'll also ask James to put it in the chat. So if you have questions, make sure you keep track of your questions. If you have questions after this, feel free to email me after the presentation. Some of your questions might actually require us setting up, a meeting with other participants or people who you need to be working on ERPOs with. We'll do that. So I just wanted to make sure that everybody knows that I will be available to answer questions, even if we don't get to them during the presentation. We will do them offline. Okay. So extreme risk protection orders, that's a Supreme Court order prohibiting a person who may be a danger to themselves or others from possessing any firearm. Remember, that means handguns or long guns, rifles or shotguns, or going forward and purchasing any firearm, rifle, or shotgun. I can't really, the importance of this, I think that we see this constantly because I don't know how many times in the multiple tragedies that we have witnessed in the United States, you see somebody who actually, it's one thing when the firearm is illegal and maybe nobody, could have tracked it. But multiple cases around the country have happened with people who have purchased legal firearms and should not have been allowed to do so. So I think we all see this, and this is an opportunity to try and, use these laws to prevent these tragedies. Next, thanks, James. Next. It's commonly called a red flag law. By the way, if you're interested, the New York State court system, and we have a public website, newyorkstatecourts.gov. We actually have statistics available about red flag laws in the 62 counties in New York State. So you can go on our public website and look up statistics, which I think are very interesting. I think it's under the category when you look alphabetically under court research, and then it will take you to, in fact, you can look up order of protection information there too. But if you would like to look up ERPO, Extreme Risk Protection Order information, you can find it there. We actually make available on a real-time basis things like how many orders were issued in a year, how many orders were issued by county, by month, who the petitioners are in general, the age of the respondents, et cetera. So there's a lot of information on that dashboard. To give you an example, there were almost 6,000 ERPOs issued in 2025. Interestingly, just because 1,400 almost of them were issued out of Suffolk County. The counties that followed, with many, many fewer, but remember, the population of the counties differ. Suffolk County, I think, might be 1.5 million, in fact, or something close to that. So the counties that followed, with many fewer, but still, like I said, it's it has a lot to do with being proportional to the size of the county, are Dutchess and Rockland and Ulster, Orange, and quite a few from Saratoga and Washington, which are all counties with many, many fewer residents, but still they have, the highest number after Suffolk County. So you can look up and see how each county is doing, who the petitioners are, and lots of other information on our public site. Yes, thanks, James. Next. So the purpose of there's sort of a dual purpose to the red flag law. You want to prohibit the purchase of the guns. You want to prohibit possession of the guns. And you want, so I should say three really purposes. And you want to make sure that you're removing the guns that are already owned or possessed when a person may be a danger to themselves or others. This is codified in the New York Civil Practice Law and Rules, what we refer to as our CPLR, in Article 63-A, which is the Extreme Risk Protection Order. And within that article, there are multiple subsections, 6340, 41, 42, 43, that all give you information about red flag laws and exactly the application process, et cetera. Next. Interestingly, I think this is counterintuitive, but well, first of all, it must be filed in the Supreme Court. It's a civil proceeding, so you're going to be filing it depending on the county you're in and the size of the county and where your courts are in the Supreme Civil term, not criminal. So there are no criminal charges or penalties associated with ERPO. Hence what I just said, that the codification of it is in our CPLR, our Civil Practice Law and Rules. Next. So in the beginning, who could make the application included district attorneys, law enforcement, police officers, school administrators, interesting, right? And family or household members. And the definition of who that applies to really is just what I have here. But, I think in general, we know what that is. Next. But in 2022, this changed, and the statute was amended to include, go ahead, James. It had two sort of amendments. One, instead of a may, it said shall. Police officers or district attorneys shall file an ERPO. Part of the reason probably that Suffolk has so many, as an example, upon the receipt of credible information that an individual is likely to engage in conduct that would result in serious harm to himself or others. A lot of you are familiar with the Mental Hygiene Law 9.39. Unless, of course, the police officer or the DA says there's no probable cause for that filing. So that was one change back in 2022. Next, the second change is something referred to in a Dear Colleague letter that went out just a few months ago in October of 2025. I don't know how many of you have seen this, but the Commissioner of the New York State Department of Health, James McDonald, along with the director of the Governor's Office for the Prevention of Domestic Violence, generally referred to as OPDV, sent a communication to healthcare professionals. First of all, informing them that as of 2022, in fact, CPLR 63A added healthcare practitioners to the list of people who could file ERPO petitions. The letter also says Public Health Law 2805Z requires healthcare professionals to be doing domestic violence risk assessments in the hospitals. And the letter encouraged healthcare professionals to try and see themselves as playing a key role in preventing these tragedies by reporting individuals who have these significant mental health issues. The New York State Department of Health also created its own ERPO guide. And I wonder what basically the commissioner said was that under the red flag law in New York State, healthcare practitioners who have treated the respondent, that's the person the order is against, within 6 months, immediately preceding the filing of the petition, are now valid red flag law or ERPO petitioners. And I'm going to give you the list in a minute of who counts as a healthcare professional. And it means that the New York State law allows healthcare practitioners to play a key role in preventing tragedy by reporting the individuals. So they asked that for information on how to support domestic violence victims at work, please visit the guide that was created by the New York State Department of Health. And the guide will also give petitioners the steps for filing an extreme risk protection order. Next slide, I'm going to, so the following healthcare providers who have treated the respondent in the preceding 6 months can petition for ERPOs. And you can see here, licensed physician, psychiatrist, psychologist, registered nurse, clinical social worker, clinical nurse specialist, nurse practitioner, clinical marriage and family therapists, registered professional nurse, a social worker, master social worker, or licensed mental health counselor. So that's a fairly significant number of additional people, additional types of professionals who are eligible to now petition for ERPOs. I'm not sure what's been done in general in the medical profession or by the hospitals in this area. I am actually meeting, just as an aside, here in the court system, I have a grant up in Erie County. It's a $1 million grant to work on firearms issues. And basically, the basis of this grant is that there are a lot of laws, like the ones we're talking about right now. In fact, about the new law about the healthcare providers, new laws about law enforcement in the DA's offices, and ERPOs in general, plus many, many other statutes, relating to firearms that are on the books. And the question are they being implemented? And is one of the problems with implementation that communication between courts, law enforcement, DAs, civil attorneys, survivors, and advocates is sometimes difficult to implement and difficult to maintain. So that grant is really about where are the gaps and barriers in making sure that we implement all of these firearms statutes. So included in that, in fact, is ERPO. And we're going to be looking at that along with many other things, including firearm directives and orders of protection, which many of you are probably familiar with. And we will be meeting with the department, I think the Department of Health or Mental Health in Buffalo tomorrow. And I'll be very curious to talk about this letter and see whether, where they stand and what they've done. Because I think, logically, one would expect that the best way to handle something like this is for medical professionals and hospitals to be linked to law enforcement and allow them to provide the information and law enforcement to be maybe the actual petitioner. Next slide. One of the things that, of course, was very important to the mental health community and the healthcare community in general is the issue about patient confidentiality. So the CPLR section that added all of the healthcare professionals deals directly with confidentiality. And it says that healthcare providers who are authorized to petition for an ERPO, when they are petitioning for the ERPO, they are also authorized to disclose protected health information, obviously, otherwise it can't be done. So they have to make reasonable efforts to limit the information to the minimum necessary for the full investigation. The court, though, right, will issue the orders. The judge who's going to be reviewing the ERPO is really going to be the one asking for the clinical records and documents that the court feels they need relating to the respondent's diagnosis and treatment so that they can do a full investigation and decide what should be done. We have all kinds of sealing mechanisms in the court. So part of the confidentiality issue was addressed by giving the court additional sealing responsibility. The healthcare provider's decision to do this, when made in good faith, cannot be the basis for any civil or criminal liability. And that, of course, is of tremendous concern also. You know, that's similar. Some of you may also be mandatory reporters in the child abuse arena, and those kinds of issues come up in those cases too. Next, thank you. Okay, so how do you apply? The chief administrator of the courts adopted forms for this process. Now, application forms are available online, and all of the other forms that we need, the court needs to respond to your application, are also available to our court staff on our internal website. And the reason I mention that to you, and we're going to talk about them, is that it should never happen that you head over to Supreme Civil Court, encounter a clerk, and somebody says to you, I don't know how to do this. I don't have any forms. Because in fact, all of these forms are on the internal website that everybody in the New York State court system who works in the New York State court system has access to. Next. So publicly, how can the public know about this? What's available to you at NewYorkStateCourts.gov? Next. Okay. We have a lot of information on our website. So first of all, NewYorkCourts.gov. We have step-by-step filing instructions. So we have, and you can see this is forms, it's under forms and court forms. And you can see that right on our website, we have how to file an extreme risk protection order application. Go ahead, next, thank you. And these are, we have an application form on our website. We have fee waiver forms. I'm going to talk about that in a minute on our website. And then in our internal website, as I said, we have multiple fillable PDFs and plain PDFs for our judges and our clerks to use in order to respond to your petition, which is anybody's petition. On our public website, we have NewYorkCourts.gov help. And the link, you can see that also under the safety and violence section, we have extreme risk protection orders. You know, on our public website, next you'll see that our information on these sites is written in plain language, where we try very hard to make sure that while a lot of you are professionals and will find it very easy to go through the application process, also remember I said earlier that family members can also apply for these. So we're very conscious when we create these sites and the forms that they are in what we were going to say plain language, and that what you're seeing here, which is our public site, if the public or yourselves want to read through this, we have, you know, we talk about what the ERPO is, the basic steps in the case, and how to apply. Inside our court system, we have really provided our clerks and judges and everybody who works within the unified court system every possible order or form that anybody would need to address the issue of extreme risk protection orders. So nobody is needing to make this up as they go along. An actual fillable extreme risk protection order is on the site for the judges. The form where the respondent, the person who's, you know, the target of the ERPO, there's a form for them to list what firearms, rifles, or shotguns they have. We have the order if the judge denies the application. The temporary order, actually called a TERPO, converts to a final extreme risk protection order. The final is on the site. Notification about the hearing is on the site. As you can see from here, orders regarding the application to amend or vacate an extreme protection order. So I list these only to show you that all of the mechanisms the courts need to respond to the application are basically in fillable PDFs. How does an ERPO actually get filed and decided? Okay. First, in the Supreme Court of the county where the respondent resides, the petitioner files something called an RJI, request for judicial intervention, a sworn application for a temporary ERPO, and supporting documentation. The next. A request for judicial intervention is a very simple form. This form, when you're filling this out, is really basically just lists a variety of types of judicial interventions, and the ERPO, Extreme Risk Protection Order, is just listed in a long list of potential judicial interventions. So this is basically just to alert the judge as to what it is, what type of request you're making. You do not have to pay a fee for filing the RJI. This has come up a few times, so it exempts extreme risk protection order cases from paying the fee. And there is not the motion fee that is filed with the RJI is not assessed either. And if there are any other ERPO filing fees that anybody is told about, we even have this available to the public, an application to waive the ERPO filing fees. So in other words, there's no reason not to do this, especially for, obviously this is not so much for people who are doing this through their profession as much as it is for the family members. We don't want anybody not filing an ERPO because, they can't afford to do so. Okay. So the application or the petition for the extreme risk protection order is, several pages. Again, I think it's basically very easy to work through, and it's going to ask if the petitioner knows or has reason to believe that the respondent has firearms, rifles, or shotguns, and the location. I'm going to talk about the application in a minute. It doesn't matter if you know that. That is relevant to whether there's going to be a search warrant issued in addition to the ERPO, the ERPO order, right? But you don't have to know anything about the firearms. You can fill in that portion, but it is not required to file the petitioner, right? But the petition is just about whether the respondent is a danger to themselves or others. So the application asks a variety of questions. The beginning of the application is just going to ask about petitioner information. And it just asks basically, is the petitioner, are you law enforcement? Are you a district attorney? Are you a family or household member? Are you from a school setting? Or are you any one of the very long list of mental health professionals that we talked about earlier? And it will ask what your business address is and how you can be contacted. And then it will ask in the checkoff boxes, the factual basis for the petition. So obviously threat or act of violence towards himself or others, and any of these other things. So a lot of people that check off everything, okay? Or maybe you don't necessarily know if there was a prior ERPO, DAs or law enforcement will, but other people might not. But again, any of these things that apply, you're going to check off. And also there's an other where you can put, add whatever else and write in whatever else you want. And then you can keep going. You can then it will ask you for the facts and circumstances. And I want to again say that it's within a 6-month period. So the petition asks you that though. So you don't have to remember that for yourself. The petition will say, did the above acts occur less than 6 months ago? It may ask you for information about where the target of the ERPO resides. If you know, you may not know, but if you know, it's going to ask you that. And then it's going to ask if you have any documentation that you wish to attach. You don't have to attach documentation. The court may ask you for some of the documentation. Obvious documentation are the medical records. So we talked a little bit about the fact that that's going to be at the judge's direction and how that's going to be handled. And in the petition, it talks to you about the sealing and how that's going to be handled, which is by the judge. And there can be other documents that are attached. You know, it could be police reports that were filed by the survivor previously, or photographs, or, you know, any one of, or a social media postings. So it could be anything. Now, optional. So this is optional. What we just talked about here, the beginning of this, the actions, the behaviors, the mental health of the petition of the respondent is really the basis of the ERPO petition, but it's going to ask a little bit more. So does the petitioner know or have reason to believe that the respondent already owns, possesses, or has access to firearms, rifles, or shotguns? And if so, it's going to ask you to give a description of what you know and the physical location. So remember, it really depends a lot on who the petitioner is. If you're law enforcement or the district attorney's office, you may have information about this. If you're a healthcare professional, you might not. Family members, survivors, right? You know, parents, intimate partners, they're going to have this information. So sometimes this will be filled out and sometimes it won't be filled out. And the petitioner can also request that the court direct a search of the respondent's home, person, or vehicle for firearms, because they know that they exist. They can explain why. The petitioner can request, again, a lot of this is, you know, language that law enforcement is familiar with, but I just want you to understand all of the things that are in the petition so you can see what it's trying to do. It's going to request, and then the judge will order that this search can be done at any time, day or night. And then there are other options in the petition, which can also add confidentiality, petitioner's name, petitioner's address, etc. Then the petitioner signs, you know, the petition.
I apologize. Am I on the correct slide?
Yeah, I was just, yeah.
Okay.
Next.
All right.
Okay. Can a minor be the target of an ERPO? And the answer to that is yes. Okay. And if so, both the parent and the minors and the minor have to be notified. The minor, in fact, will, because it's a minor, the name will be anonymous in the court filings. Now, minors can't legally purchase firearms in New York anyway, but this is still, you can make sure that a minor is the target of an ERPO. Next. Okay, so that I just talked a little bit about the application for the temporary extreme risk protection order. This is, like I said, available to the public and to you on our public website. This is what it looks like. So once you have filled out the petition, it has to be filed, because the petition is going to get filed and then it's going to get sent by the clerk to the judge. So what happens if you need to file this outside of normal business hours? For counties outside of New York City, we have an emergency phone number and email address for police officers and district attorneys to reach a Supreme Court justice. And this is actually, this is the contact information, and this is how when you're off hours, when the courts are not open, because most of the courts are 9 to 5, obviously. This is how law enforcement or the district attorney's office would reach the courts if they need a temporary extreme risk protection order, and it's not when the courts are in session. So we have a system set up. It comes through this emergency system. It gets transmitted to a judge who's, probably at home and is going to hear the application over the phone. The judge is going to issue the order over the phone. It's going to get entered, etc. And the TERPO will be sent to law enforcement for service, and it is in effect. So it's not like, if an emergency situation comes up, but it's the weekend that, there's nothing you can do. In New York City, it's a little different because the courts are operational for different amounts of time. So during off hours, they can do it in the New York City criminal court. The court staff knows about how to file and register these temporary extreme risk protection orders. And it's included, it says here, it's on our public website of how to actually file these if it's not daytime. If it's daytime, as I said earlier, you're going to go to Supreme Civil Court and see a clerk. The issue that comes up for people who are healthcare professionals, most frequently, but for everybody, has to do with sealing and confidentiality, regarding exhibits, medical psychiatric records, addresses. The petition, as I mentioned before, speaks to this quite a bit. So the judges, when they are determining the temporary extreme risk protection order, will also deal with sealing and confidentiality. As I said before, when the respondent is a minor, it requires anonymity in the title of the order. And then when you're dealing with the clinical records or medical records of the respondent, they have to be sealed. But again, that has to do with the CPLR and our courts. It's the judge's responsibility, not your responsibility or any petitioner's responsibility to worry about that. An applicant can also request anonymity. As I said before, in the actual application, there's a section that is not only about the confidentiality of medical records, but, and I said, as I said, minors have anonymity, but generally petitioners can request anonymity also. Next. So depending on the county you're in, who actually is the ERPO judge differs. In many of the counties outside of New York City, we have pistol permit licensing officers. That person is usually a judge. And generally speaking, the pistol permit judge is the judge who hears all of the ERPOs. They have to be, in many counties, the county court judge happens to be the pistol permit licensing judge and would typically be the person who would be issuing the ERPOs. I mentioned before that ERPOs are a Supreme Court order, and that means that a county court judge has to be an acting Supreme Court justice in order to hear the extreme risk protection order application. Most importantly, these are urgent applications and they have to be heard and decided the same day they are filed. So it cannot be a situation where somebody goes in with an ERPO, an application, and the court says, okay, I'm going to take the petition and I'm going to tell you to come back in 3 days, right? There are different kinds of petitions that come into the court system where sometimes that happens. So we're not discussing that now, but I am saying that it can never happen with an extreme risk protection order. So we have put in place, like I was talking about previously, different emergency designations and systems for when the courts are not open. So you must be heard immediately. Next. So in the 5 boroughs of New York City, the ERPO and the RJI and the request for judicial intervention are filed in the civil term through the county clerk's office and then immediately transferred and assigned to a Supreme Court justice in the criminal term for decision, but is filed through the civil term. And again, as I said, the ERPOs are urgent applications and they have to be decided the same day. So if you're in New York City and you're doing this, even though, like I said, intuitively, you might be heading to the Supreme Court criminal term, you have to first go to the county clerk's office in the civil term. They will tell you what to do. Only Supreme Court, by the way, has to be Supreme Court, county clerk, civil term, not the regular civil courts. Okay. So the judge, now you filled out the petition, you filed with the clerk's office, and then what happens? So after considering the application, any other witnesses or testimony, the court can either grant the application, barring the respondent from purchasing any firearms, like I said, handguns or long guns, and order the respondent to surrender anything they possess currently, or order the removal pursuant to a legal search of any of firearms that are in the home or the vehicle or on the person. Alternatively, of course, a judge can deny the application. The TERPO, right, is a written order. The judge has to include the grounds for issuing it, the expiration date and time, and a statement in it telling the respondent that they cannot go out and purchase any firearms and that they are required to surrender right then and there the firearms that they currently have. Now, after the hearing on the temporary order of protection, there will be a hearing will be held to determine if a final extreme risk protection order will be issued. So part of that temporary order, they're going to tell the respondent they can go out and get an attorney, the date, time, and location of the hearing. It will be held not later than 6 days after the TERPO is served. And they can request additional time to prepare for the final extreme risk protection order hearing. Next slide. Okay, so what will be included in the protection order, the actual order that is served on the respondent? Once the judge decides that there's probable cause to believe that the respondent, the target of the ERPO, is likely to engage in conduct that would result in serious harm to themselves or others as defined in Mental Health Law 9.39, and they decide to grant the order. What does the order do? So this is really significant because think about a lot of the cases that we've seen in the country over the last several years. So the respondent, the target of the ERPO, is prohibited from purchasing, possessing, or attempting to purchase or possess a firearm, rifle, or shotgun, and shall immediately surrender any and all firearms, rifles, and shotguns they currently own. Secondly, upon service of the order, the judge has just issued the temporary order, the target is required to list all firearms, rifles, and shotguns in their possession and the location of each firearm. in the list that, that is going to be provided. Okay. For purpose of the listing, right, the term possession means physical possession or the ability to exercise dominion or control over the property. The judge can also order that upon service of this order, the law enforcement agency that's serving the order, we're going to come to that in a minute, shall request that the respondent immediately surrender firearms in their possession. So there's no like, okay, I've gotten this and I will surrender my firearms in a couple of days. Just tell me where to go. And that law enforcement shall conduct a search for the firearms and take possession of any that are in plain sight, or if the target says, yes, you may search my home, any that are discovered pursuant to a lawful search. Additionally, an option on this order is consistent with search warrant procedures, which obviously are something that law enforcement and district attorney's offices are aware of, which is codified for everybody, for them, just for purpose of knowing this, in Criminal Procedure Law 690. The judge at that moment can also authorize a search and seizure. So the judge can issue a search warrant along with this TERPO, okay? And it authorizes the petitioner, if the law enforcement, to search for firearms, rifles, and shotguns in the respondent's possession. That search can be authorized day or night, anytime, and the search will authorize whether the search is of the person, the premises, or the vehicle. And again, it authorizes an actual search. So when when law enforcement gets there, and if they're aware of or they believe that there are firearms or there might be firearms, they're going to tell the person to surrender them. If the person's like, well, I don't have any, right? They're going to have a search warrant with them. They're going to say, okay, sort of like the easy way and the hard way, right? Because I'm now going to search your premises. So if you have any, and you don't want me to search the entire premises, although they might still continue the search, voluntarily surrender. The order will also will also direct the confidentiality issues and the anonymity issues if the petitioner is requesting it. The order will then also say when the temporary order expires and when the hearing for the final order is going to take place. Go ahead, James. Okay. Important to know, again, this talks a little bit about, to what's going on in the country. As soon as the ERPO is issued, the temporary order is issued, it is sent to the FBI. Okay, it gets transmitted automatically to our federal partners so that it is there in the federal database immediately that this person, it suspends their firearms license and it disqualifies them from purchasing firearms. So that will be, then the immediacy of that, I'm sure, is not lost on anybody. It has to happen right away so that if the person attempts to go out and purchase a firearm quickly or not quickly, they will be barred from doing so. Because, obviously that the people who are dealing in firearms have to check the firearm registries to see if the person is barred from purchasing. You can be barred from purchasing for many reasons, which we're not going to go into today, but, obviously having to do with orders of protection and a host of other things. But ERPOs, the existence of a temporary extreme risk protection order against you is part of this. Now, how does that get served, right? How does the order that the judge issues? So now we're like walking down the chronological road, okay? Petitioner filed a petition. They attached the documentation. The petition got filed with the county clerk. The county clerk called the judge who is on call or doing on ERPO duty to come and do the hearing. The judge did the hearing. They reviewed everything. They issued the ERPO. They issued the immediate surrender. They might have issued a search warrant too. And then what happens, right? Because the judge is issuing that. That's a piece of paper. It's an order. Then it has to be served that on the respondent, and it should be served obviously by law enforcement. So when it is served and law enforcement goes out there, the officer is going to take possession, because remember, the TERPO bars not only purchase, but possession of all firearms, rifles, and shotguns in plain sight or discovered pursuant to a lawful search, which could be consensual or because there's a search warrant attached. And it can, as we said before, they can search the respondent's person, the home, or the vehicle. Whatever is directed, remember, this is not your problem. This is directed by the judge in the court order. This is what the firearms list looks like. This is available to all of our court staff. So again, I'm showing you this because I want everybody to realize that we have made this as simple as possible. And we have created fillable forms for everything that's related to extreme risk protection orders. So nowhere in the state, no matter what county you happen to be from, if you're listening to this, does anybody have to get out there and pull out a piece of paper? This includes, by the way, our town and village courts that, we have hundreds of those all over the state. They don't have to pull out anything, okay? So this is what the listing of firearms, rifles, and shotguns that would be provided to the Supreme Court looks like. Next. Now, it can happen that the TERPO is denied. Interestingly, even if the judge decides to deny the temporary extreme risk protection order, they still hold a hearing to determine if a final order should be issued. This is to give an opportunity to the petitioner. Maybe the petitioner's ability wasn't that thorough or artful in filling out the petition. This gives the judge the opportunity to listen to the testimony again and make a redetermination to be sure that they're doing the right thing. The final hearing has to be held no later than 10 days after the denial order. And again, the court can grant additional time to the respondent to prepare for the hearing. So there's like a second bite at the apple. We have a form up there denying the application too. Like as I said again, nobody has to invent anything. Next. So the court, so once the court holds a hearing, unless the petitioner withdraws the application, okay, along with the order granting or denying the temporary extreme risk protection order, the respondent must also be served with a notification of the hearing, the date and the time and the location. So when dealing with firearm legislation, having not only to do with ERPOs, but really across the board and across the entire country, the statutes are very, very careful to be also addressing the safety issues on behalf of the petitioners, but also to be very cognizant of the due process rights and the rights of the respondent. So, you're going to see a lot of that also in the way the statutes are drafted. Only 22 states have red flag laws, by the way. And interestingly, not New York, obviously. There's several states that have anti-red flag laws. Like the legislature has passed something saying that you can't, create a red flag law. So, attitudes towards this really differ around the country. Next. This is a notification form for the respondent about the hearing for the final extreme risk protection order. Okay, so whether the temporary extreme risk protection order is granted or denied, the court has to do a background investigation and get a report from the local law enforcement agency for the final ERPO hearing. So there are several things that go into that background check. Many of them will not be surprising to you, but there are several things that go into it. Next. So the background investigation and report must indicate if the respondent has prior convictions for domestic violence, for criminal possession of a weapon, or other violent type of arrests. So remember, it's convictions, criminal convictions, not, dismissals or ACDs, for those of you who are familiar with that terminology. If there are pending criminal charges, is currently on probation or parole, or possesses any registered firearms, rifles or shotguns, or has been the subject of an order of protection or a violation of an order of protection proceeding. So for the background investigation on if you've denied a temporary extreme risk protection order, whether you've denied it or granted it, but the courts are directed that you have to keep going with this, right? For the final extreme risk protection order, you're tasked with making sure that you have gotten this information before you make like a final call. Next. Thanks, James. Okay. This is the order that the courts can use to direct that a background investigation take place. So when an ERPO application is heard, ex parte means, obviously, when you go in for the temporary extreme risk protection order, just like those of you who are familiar with going in to get an order of protection in family court, there's only only the petitioner is there, right? The respondent doesn't know that the petitioner has decided that the healthcare professional, the teacher, the law enforcement person, the DA's office has decided that they should be the target of an ERPO. So the court must direct that the respondent is served with the order, obviously, because they have to know that it's happening, either granting or denying it. Application, the application subject to redaction, and the supporting documents. Next. Okay. The court directs service. Okay. So when the court finishes the order, they direct the service by a local law enforcement agency, or it's always local law enforcement agency. And especially, obviously, since if the ERPO requires surrender or search, right, search warrant or anything for firearms, rifles, or shotguns, it has to be local law enforcement, okay? Apparently, the statute allows third party, but we're not going to talk about that because it's always law enforcement. The court must direct, it has to be by law enforcement. Next. So the service should take place immediately. The courts will be transmitting that ERPO to law enforcement immediately, and law enforcement has to act on it immediately because, timeliness is really important, especially because, you're transmitting this to the national databases. So it all has to happen very fast. Next. Okay. It's always better to have the petitioner be law enforcement or the DA's office that has access to law enforcement, because if the officer is present in the courtroom when the judge decides the application, he can immediately hand it to the officer who can then go out and serve it. But if it should happen that that's not the way it goes, our court system will immediately email or fax or, serve whatever, reach out to the law enforcement agency that's being directed to serve the ERPO and make sure that they've confirmed receipt. So generally speaking, especially if you go on our website and we have statistics that show you who the petitioners are, you're going to see that most of the time it's law enforcement, almost always. So basically, most of the cases, you're going to hand deliver the ERPO to law enforcement. But for the cases where that doesn't happen, it's the responsibility of the court to get the transmission of the ERPO to law enforcement. And they will do so. Okay. It is also the responsibility of the court to make sure, okay, that the New York State Police, our Division of Criminal Justice Services, and all law enforcement agencies in the jurisdiction and the firearm licensing officers are all notified. So there's an enormous number of notifications that go along with the issuance of an extreme risk protection order, which, is for obvious reasons. I want to make sure that all law enforcement and especially the purchase databases are aware of what's happening. Next, thank you. Okay. I'm just going to go through very quickly because it's almost 2 o'clock, just that we have the final extreme risk protection orders. Go ahead, James. And much of this is really the same. The petitioner has to prove by clear and convincing evidence that the respondent is likely to act in a way that would result in serious harm. The court's going to consider the application, the petition, the testimony, the evidence, supporting documents, and the court's going to issue a written order, just like the temporary order I described. This is a copy of this is what a final order looks like, very similar to what I said before. Next. If the final ERPO is granted, everything that was previously seized on the temporary order is retained by the law enforcement agency. Again, prohibition on purchase or purchasing or possessing firearms licenses are permanently or for the duration of the final ERPO suspended. Okay. The final ERPO has to have an expiration date. It can be up to a year. You can then apply for another one. Next. So everything that was surrendered and searched, etc., that was in the temporary extreme risk protection order is transmitted into the final risk protection order, and all the notifications are the same, especially obviously to the feds. Next. Okay. As I said, these statutes provide a lot of protection for the respondents. Also, if the weapons have been surrendered because of the temporary order, but the final ERPO is denied, there has to be a written finding as to why they should be returned to the respondent. And the prohibition is lifted and the case is over if it's denied. But again, I'm going to say that the applicant, before everything gets returned, there's a very serious written finding as to why there's no legal impediment to the person possessing them. And when so notifications, when the final ERPO is denied, the same notifications take place so that the respondent's protected. The respondent's rights are protected. Go ahead. Thank you. Okay, and we have orders, an order denying the issuance of the final extreme risk order. Again, I'm just showing you this so you know that nobody has to reinvent the wheel every time you walk into court. Go ahead. Thank you. Okay, so my Anthony Perry is our Deputy Counsel for Criminal Justice, and you can reach out to him with ERPO questions. You can reach out to me anytime at lcsmith@newyorkcourts.gov. I wanted to make sure that we could stop at 2 o'clock. And if you, like I said, I'm happy to answer the questions offline because a lot of them are probably pretty complicated and will might involve individual issues that you have in your counties that need to be resolved because we're unaware of them, but will probably need to be resolved by our having a conversation and trying to connect up the dots. Thank you.
Right. So we can keep the recording going while we answer a couple of questions. If people need to leave, we fully understand. So for the first question, yes, SAMHSA was refunded. We can talk about that after the Unified Court Service folks leave. Where do NAMI volunteers and staff come in? Not necessarily certified or unlicensed, i.e. certified peer advocates, family members. I would say that that's part of the conversation we're having about family members, general public, right? We can talk about how NAMI members can provide this information to the loved ones, and if they feel that their loved one needs an extreme risk protection order.
So
one question
really,
came in.
Right. Oh, I'm sorry. It's just really important that, I'm sure we all agree this is really not out to the public in the way it needs to be. And we've had countless tragedies pointing to that. So, I think it's really important that everybody is connected to law enforcement, because it makes the most sense for law enforcement to be the petitioner. And if you are talking to family members and it's clear that you need to have an extreme risk protection order issued, then hopefully within your clinical setting, there's a conduit that's been, a protocol established for a conduit. And that's what we really need to ensure is happening.
Another question was, does the ERPO Act differ from New York SAFE Act?
So they are different. And so that's like a really long question. So just the SAFE Act speaks a lot to orders of protection. Just so that the beginning stage of the SAFE Act is frequently around the fact that somebody has either there's an arrest and a criminal order of protection is being issued, they're already in court, they're being arraigned, or somebody has gone in to get an ex parte order of protection in the family court. Their basis for the orders of protection is different, right? It has nothing to do with the person. Well, it could have, but it's not based on the person being a danger to themselves or others. As you all know, it has to do with violence in the home and stalking, threatening, etc. And within the context of the order has many portions to it where there are directives about firearms. So similar prohibitions exist in that SAFE Act. The point of the SAFE Act, when you're talking about firearms, is to do the same thing. It's to check off the firearm box on the order of protection so that you prevent the purchase, and to check off the firearm box so you can get law enforcement involved in the surrender. But this doesn't require that there be an order of protection issued. This is about the mental hygiene law.
We have another question, but the person is still on. Rachel Newton, you should have the ability to take yourself off mute if you'd like to ask the question.
Hi, Lisa. So I'm the ERPO liaison at the Erie County District Attorney's Office. I know you have the grant with our county.
Yes,
so
yes. Hi, I work with your colleagues a lot. Yes.
Yeah, so we have a problem in our county, but I think it applies to all of the other counties, not including downstate, concerning the after hours application. So
Rachel, wait, I'm just going to stop you for a minute.
Sure.
Okay. Send it to me in an email, and I'm going to talk about it with the grant team. Okay. And I'll get you on the call, and we have the sheriff on the grant team and everybody. So let's just get everybody. Okay, let me look at it offline and try if I see what the problem is, because the point of the grant is that whatever we work out in Erie, we're going to try to replicate. So I want to go through this because I'm sure what you're going to tell me is like a significant problem and is going to need significant attention from me. Okay.
Okay, will do.
Okay.
Thank you.
Thanks.
Okay, we had another question from Bill and Marie and Neiman. If you guys want to take yourselves off mute and ask it.
Yeah, I noticed that, or at least I think I noticed that when you were describing the procedures for the application and then for the initial application for the temporary order and the background investigation for the final order, none of the criteria said anything about serious mental illness. So I gather then that the criteria is based only on the explicit threat of harm.
You mean the danger to themselves or others?
Right.
So you're saying like the person is seriously mentally ill, but they're not a danger. You don't feel that they're not a danger to themselves or others?
No, my question is more that
evidence of serious mental illness would 100% be part of what the judge might be asking the health professionals or anybody else who is coming before them to apply for the ERPO. It's just that the language in the ERPO would require that they also say that they would be following the mental hygiene law and saying that the person, so it's not that they wouldn't be relevant, it would be totally relevant. They just have to have the other language also.
Okay, thank you. It's my reaction to that is that this is somewhat similar to the the concerns with assisted outpatient treatment, that the individual actually has to become dangerous before treatment can be provided through this mechanism, or through, in that case, the AOT case, or before weapons can be removed in the ERPO case. That so it may be too late. It may be locking the barn door after the horse is stolen.
Right. Although I get the sense from seeing these that the danger to themselves or others can be, does not, it doesn't say it has to be proven by, a series of attempted murder arrests. It's it's that I think that they are a danger to themselves or others, but I also want to tell you that all the following has also occurred. I think that's why there's so many boxes in the application. They're trying to give a broader picture of who the target is.
Okay, thank you.
I would also say that there's likely a restriction on saying that a person has been an illness, therefore loses right X, right? It has to be based on what the individual is doing at the time that warrants the decision that they are potentially dangerous.
Thank you.
So with that, there's another individual had their hand raised earlier. You should all have the ability to take yourselves off mute if you'd like to ask a good question. David.
I just took a look at the SAFE Act, and from what I read, it said that it is required if someone is a mental, and the same list of who were required. Whereas ERPO, it's kind of, it's not required. It's just, if you think. It's kind of voluntary. Is that correct?
I'm not 100% positive as exactly what you're referring to, so I would have to take a look at that to see if that distinction is exactly accurate. So if you would just email me that question, I'll have a chance to delve a little more deeply into it and look.
Okay.
I think that I think it is true that the ERPO law was written to be a little vaguer than people are generally accustomed to some of these firearm removal statutes being. But just send me the email and I'll take a look at it.
Okay. And your email is available?
lcsmith at newyorkcourts.gov. It's nycourts.gov.
Both emails are available in the chat. I copy paste your contact information for anybody who wants to copy it that way. Okay, we'll give folks a chance to ask questions. We are going to stop the recording now. Up until this point, it will be posted to the internet, but we'll allow folks who do not want to ask a question during the recording